All right.
Good afternoon. On July 16, 2009, Erin Andrews, whose career and whose life was happy sailing along, was in Los Angeles to meet with a new agent and to talk with the people at Dancing with the Stars about being a contestant on the show. Over the course of that day, as she was in a variety of meetings, she was receiving messages from her friend, a sports blogger named Jimmy Traina. She gets back to her hotel room and she calls her mom and dad to tell them how well things had gone that day and how excited she was. This 29-year-old girl, graduate of the University of Florida, who had had a dream of being a sports personality sideline reporter ever since she saw Hannah Storm do it when she was a youngster, meaning Erin. She gets back to the hotel room, and after talking with her mom and dad, she gets on the phone and calls back Jimmy Traina. And Jimmy says, "EA, you're on the internet and you're naked." And Erin Andrews, EA, said, "Jimmy, that can't be. I don't do that sort of thing. That's not me." But she could tell in his voice that he was serious. And she turned on her computer and she looked. And within 2 seconds, she was screaming wildly. She called her mom and dad, screaming so much into the phone as they received the call from their home in Tampa, Florida, that they couldn't understand her. They thought she'd been involved in an automobile accident. And she just screamed and screamed, "I'm all over the internet and I'm naked." Erin Andrews, over the course of the next weeks, after flying while crying all the way back to Atlanta, putting up sheets around her windows, scared to death of what this all meant, finally ends up flying down and living with her parents and committed a resolve that you're seeing here in this case. She made a decision that she would stand up, and that she would stand up as she learned information through the investigation that started to be done against the Nashville Marriott. Standing up for the right standards to be followed and used that were not followed and used on September 4, 2008, when her information was provided to a stranger. What this case is about, as we said from the beginning, is that our hotel room When we go to the hotel, we hang out the Do Not Disturb sign. Every one of us has done this at some time or another. We close the door. We lock the door. We put that special latch up there at the top that those doors frequently have, almost like a second deadbolt kind of a concept. We are to feel secure. We are to feel protected, and we are to believe that our privacy is protected. In doing our thinking in this case, remember the theme that we started with. Don't leave your common sense at the courthouse door. In some of my examinations of the witnesses from Windsor West End, I was relying on y'all to use your common sense, because I heard things from the other side that made no common sense to me. So let's talk about those hotel standards of care and how badly they were violated in this case, to the serious detriment of Erin Andrews. And as I do this, I want to turn to Erin, and I want to congratulate her for her courage in following through on this. It has been a privilege and an honor to represent her, to speak for her back here in Nashville, where this all started, to speak for her because her courage in doing this, I mean, she has a public persona, doesn't she? She has worked so hard to develop herself into a respected professional. And yet, because of the issue of safety, of protection and privacy, of proper policies and procedures, she was willing to get on the witness stand, and you know it's being broadcast, and to reveal the other side, to reveal the pain and the severe emotional distress that this causes her every day and will cause her for the rest of her life. That's how important these issues are to her. So much so, you know, we talk about some witnesses being really honest. Her testimony was as honest and as vulnerable as it could be. But what could be more honest than for her to be willing to let y'all see the videos that you saw last Thursday afternoon? And she left the courtroom and went to the room down the hall, and she knew that you were watching her in her most private moments completely naked. That's what this issue means to her. And you all will always be known as Erin Andrews' jury. So let's look at those hotel standards and how miserably they were violated by the Nashville Marriott. The hotel must never unnecessarily endanger a guest. Well, not only is that a standard, but doesn't it make common sense? I mean, when we go to hotels, we walk in there and we turn ourselves over to them in the room, don't we? We get into bed and we go unconscious for a while. We go to sleep. This has to be our home away from home. We turn ourselves over to them and their protection. So, the first thing they did wrong was, check this out. September 2, Michael Barrett calls the hotel and says, will Erin Andrews be staying there? Whether they knew who Erin Andrews was at the hotel or not whether it was one of us that nobody knows, or, you know, our family and our friends and our loved ones, but that we're not big names, you don't give out that information. You respond with, "I'm sorry, I can't tell you that." 5, 7 words. If you have a policy in place that clearly says at the Nashville Marriott, you tell people you can't answer that. And you know what makes common sense about that standard and about this violation? If the person that's calling knows the person they're calling about, why wouldn't they be calling the person they're calling about to ask them if they're going to be staying at the Nashville Marriott? So maybe it should have been even more than the 7 words. "I'm sorry, I can't tell you that. Why don't you call Erin Andrews and ask her?" Right from the beginning, they gave out information that they shouldn't have, and multiple hotel witnesses in this case admitted that was a violation. If that violation of the standard had not occurred, then Michael Barrett would never have been able to do this at the Nashville Marriott on September 4, because he wouldn't know that's the hotel she was staying at. So number 1, cut off the snake at the head by not telling that she's staying there. Common, ordinary sense. Wait, come back to me here a second. I did that too fast. In order to have a hotel that's well run, you need to have policies in place, don't you? Don't we all have policies in place where we work? And aren't they written down? But one of the most important policies that a hotel can have is policies about guest safety, written down. Not just word of mouth, because people forget, people get confused and everything. You write it down and people know it's important, because it's a written policy that must be followed or you will lose your job. So, they didn't seem to have a policy on this on September 2nd. Mr. Barrett calls, "Is Erin Andrews staying there?" "Yes, she is, September 4th. Bye-bye." And the die was cast. Because right after that, on September 2nd, he called back the hotel on a second time, got sent over to the Marriott call center, and that's when he said, "I want a room on September 4. I'm a Silver Awards Marriott guy, and I'm requesting that I be put next to Erin Andrews." Wouldn't have known to make that call if they hadn't given him the information in the first place. So what did Rivera Keene say? Remember that she was one of the supervisors at the front desk. And I asked her, in terms of any written policies or procedures, they gave you nothing about privacy policy for guests, right? Answer, correct. Now, she was a supervisor. She supervised Jacqueline Dement, who testified yesterday, whose JDD appears on the PMS document that you've seen, that shows the A1, C1, M4 do not move. I know you all know what I'm talking about. It's become second nature to you because it's been such a focal point of this case. Well, how in the world do you protect against endangering guests about their personal, private safety if you don't even have any written policies about it? And that's the way it was for them on September 2nd and September 4th of 2008. The hotel, the next standard. These are undisputed standards in the case. Undisputed. Undisputed. The hotel must protect the guest's safety first before granting another guest a favor. Wow. I mean, do we need to have it as a standard? Doesn't this make common sense? To protect us all? Before granting another guest a favor, that's the standard. And yet, what did they do back then? We heard from their witnesses that the idea was to accommodate the request. Somebody says he or she wants to room next to somebody else. If you can do it, do it. That's outrageous. If you're not going to call the person that this person is being asked to be put next to. And Erin Andrews was never told by anybody, front desk agent, supervisor, manager, anybody, that there was a man that was asking to be put next to her. So they gave him a favor. The hotel must not grant the request of one guest if that request could endanger another guest. The hotel doesn't know who this man is, and he's asking to be put next to somebody. Common sense. Call that person and see if it's okay. You know, Jackie DeMent yesterday testified that, yes, that call is supposed to be made. But who's it supposed to be made by? Not by her, apparently. By the manager or supervisor. Did you ever ask yourself yesterday, who was the manager? Who was the supervisor who was supposed to be calling Erin Andrews and telling her? And why haven't they brought him to this courtroom to testify? There's a jury instruction you'll hear about when parties fail to call witnesses that they should have called. Who was the manager who was supposed to call Erin Andrews and tell her and didn't? Is it because things were so lenient and so lax that nobody followed up at all? Here's another one. Who was the manager who put M4 do not move? You know what I'm talking about? Who's that manager that took that request for an adjoining room with Erin Andrews and put it in place and put do not move and then didn't call her and tell her? Why isn't that person here? The hotel must never let profits become more important than guest safety. I mean, common sense, right? But what did Ms. Rivera-Keene tell us about that when she testified? You all remember Rivera-Keene that was here a few days back? Your notes will reflect it. She said that the policy at that time to let people have the room next to somebody else if they ask for it was because they want to keep them coming back. They want to keep the customer coming back. This was a Marriott Silver Reward member guy, Mr. Barrett, and they want to keep him coming back. Give him what he wants because he'll keep coming back. That's putting profits above guest safety. And that is against standards, it's against common sense, it's against safety, and I'm so proud of Erin Andrews for bringing all this to our attention and for you all to be making the decision about this. You know, the word verdict is taken from the two Latin root words ver and dict, which means to speak the truth. You all tell us the truth about this case with your verdict. So, we know there's a bunch of violations of standards here. Mr. Delmarva explained that to you, and they really couldn't push back on a lot of those things. They didn't have the evidence to do it with. What really is helpful here is you find the answers in the documents. What a preposterous story Mr. Barrett tells us in the face of the documents. Think about it. Mr. Barrett, who is not to be believed, you heard the court say that there had to be a court order to get him to testify. Mr. Barrett, who's a convicted felon, Mr. Barrett, who spent time in prison because she went public, issued a statement so that the FBI would get involved and get him behind bars to be held accountable. So it was payback time for him, right? I know. There's this lawsuit. And I can really try to screw up her lawsuit by testifying that they didn't know that I was asking for the room next to Erin Andrews. The man had no problem, for no gain at all, putting her naked body on the internet because he had something in for her. Then she gets him behind bars, and then he really has something in for her. But you know, the story that he tells doesn't make sense, does it? It doesn't fit the evidence. He says he got there, that he was assigned to a different room or something, or that they were busy or they didn't have rooms ready, that he goes have lunch or something somewhere, not up in the concierge level, and that when he comes back, he goes to a house phone. And when he goes to the house phone, he says he called the operator and asked for Erin Andrews' room. And that when he did do that, he saw her name and number come up on the house phone, on the LCD screen, except for one huge problem. I'd let y'all tell me what the problem is, but I can't let you do that. Y'all can express your views with your verdict. But the problem is, house phones do not have LCD displays. Why? Because that would tend to violate the privacy and the protected information of the hotel guest upstairs. So he made it up out of whole cloth. And you shouldn't believe a word that came out of his mouth. And yet they build their case around him. Wow. I'll tell you what. I'll build my case around Erin Andrews and the documents and let them build their case around Mr. Barrett. So, Barrett also says that he went up to the 10th floor when he saw this on the LCD display, which wasn't even there. And he goes upstairs to where her room is, and he sees the room next door is being made up. Why would a room being made up make you think somebody's not going to be in there? Don't our rooms get made up every day when we go to hotels? But he says he then goes downstairs and goes up to what turned out to be Jacqueline Dement and says, I know what room I want. I want room 1049. You know how far they reached to try to support his story? They tried to say maybe he went to the restaurant hostess station and used a phone with an LCD display on it. Maybe that's how he got the information. It wasn't a house phone. It was an employee phone. Well, number one, what's he doing getting access to an employee phone? That's another violation. But number two, uncontroverted, Rivera-Keene explained to you that the way those LCD phones work is if somebody calls from up in the room downstairs to an LCD phone in an employee area, it'll show the name and the room number so that the person can answer the phone and say, oh, hi, Ms. Andrews. Yes, we can get that up to you right away, and they see the room number. Boom. But if the call is going from down up, and they call AYS, at your service, or the operator, and they say, can you connect me to Ms. Andrews' room? It doesn't show up because that's for protection of the privacy of the people up above. But I'll tell you something else. If they're going to have a phone system that can be accessed by people that aren't even guests yet, let alone guests, and if it can be accessed that way, and if it is designed to tell phone room numbers for up above when you're calling down below, which that's pretty non-commonsensical if you're concerned about guest safety and privacy. But if you're going to do that, then why not put a code into it so that you have to enter a code as an employee before you can get access to that phone? Or put it in places where people can't get to it. That's why Nina Rivera-Keene testified that if somebody said that they got the phone number, the room number downstairs using a telephone, that would be impossible. I'll tell you something else. That guy, when he testified, never said that he got a temporary key to go up the elevator to the 10th floor, which is a secure floor. You can't get up there without a key. He never said that. They came up with that out of whole cloth, trying to support that story that makes no sense. So where is the printout from the computer that shows he was issued that temporary key? There isn't one, because he wasn't. Because he didn't go up there to the 10th floor to find what room was next to hers. Because what happened was, and now we go back to the documents. What happened was, you all remember Takima Baker, the very first witness, played by videotape, who took the message from Barrett when he called in after checking with the hotel on September 2 and being told, yes, Erin Andrews is going to be staying here? And he calls and he talks to Takima Baker and he says, I'd like to make a reservation. And she typed in, guest request to room next to Erin Andrews. Now what you're looking at there, remember I pointed out during the trial that you look in the lower right-hand corner of that document and it has WEWC, is that what it is? I don't have my glasses on. That's the bait stamp number, what's called a bait stamp number for documents produced in a lawsuit. And that means that that was produced not by Marriott International, but by West End, by Windsor. That's what that Bates number is about. That's why I pointed it out to you during the trial through a witness, because they did get the information into their computer system on September 2nd that he wanted to room next to Erin Andrews. And I'll tell you what, common sense, think of it this way. September 2nd, he asked to be put into a room next to Erin Andrews. September 4th, he's put into a room next to Erin Andrews. He didn't care about the kind of bed. He cared about being, that overrode everything, being next to Erin Andrews. And I'll tell you something else. I know I say that a lot in this case, but it's because there's so much evidence in favor of Erin and against them, and they know they can't handle the evidence, so they rely on Barrett. They embrace Barrett the same way they enabled Barrett back on September 2 and September 4. So, You know this whole theory that's been put together by the hotel, that he first had a reservation for a different room, and that then when he got there, he was switched from the king to the double beds and stuff, and this whole other reservation supposedly exists out there, right? Where is it? If that was true, why didn't they show you a document from the computer that would support that there was a different reservation? There was no different reservation. There was one reservation and one room assignment, whether it happened on the 2nd, the 3rd, or the 4th. And that was to be put next to Erin Andrews. And I'll tell you something else. There's the guest history master, and as Ms. Dement said, that's what would have shown up on her screen. Tells you everything you need to know about what happened. Special requests. M1, K1, whatever those things are. A1, C1. You all know what that is. I've driven you all crazy about this subject, I know. You'll never forget it for the rest of your lives. A1, C1 means adjoining and connecting. That came from the call center. That came from Takima Baker, according to Jackie Dement and everybody else who's testified in this case. That means that what Tamika Baker said as the very first witness in the case is true. She took down this information from Barrett and she sent it to the hotel. Now they try to say, well, we did see that, but how? We didn't know it was with Erin Andrews. Well, who in the world did you think it was? Here you've got this Marriott Silver customer that you want to keep happy and keep him coming back, and he says that he wants an adjoining or connecting room, and if it didn't say to whom, aren't you going to find out? Aren't you going to go to Marcia to find out if it isn't there on the PMS document? Or aren't you going to call Barrett and ask him, who was it that you want to be? Of course they did something like that, and I'll tell you what else may have happened. Rivera Keene testified that that area below that says do not move, that typing of that in can overwrite what was below it. If it overwrites it, then we won't see what used to be there in the special request comments, like what Takima Baker sent, guest request to be next to Erin Andrews. But then, the only thing on that special request area that would not have come from the call center is the M4 do not move. What did Jackie Dement tell you yesterday? That only gets put there by a manager. Wow, does that tell you volumes? It's exactly what she said, Ms. Dement. When she said that that gets put on by a manager, obviously because of interaction with the customer, making sure that the customer stays happy so that they keep coming back. Now think about the alternative. Think about the way they're trying to present this. That Mr. Barrett, I have a hard time calling him Mr. Barrett, that Barrett walks up there on September 4, there's no room ready, so he goes have some lunch, and later on he comes back and walks up and says, I would like room number 1049. Why would they then type in, do not move? You need a manager to do that. Why would Jackie Dement, if it didn't already say that there, why would she say, wait a minute, I know you want 1049, but I need to go get the manager because we need to see whether we need an M4 do not move? That's all malarkey. It's ridiculous. No. What happened here was really simply summed up yesterday when I read back to dement her testimony from her deposition. And she was asked whether Barrett ever said to her that he wants to be next to Erin Andrews. And do you all remember what she said? I don't think he asked me directly. No. It was already in the system. Verdict. To speak the truth. You all know what happened. It's as plain. I hate to talk about the nose on my face because it's not a small one, but it's as plain as the nose on my face. So, what does the law say? We already know that the judge has directed a verdict against Barrett. You all know what the evidence is on that. The verdict you'll be focusing on has to do with Windsor and West End. So let me show you a little bit about the law on this, and you know what? The law in this area makes such common sense and has everything to do with the safety for all of us that we talked about with those standards that protect all of us and our families when we go to hotels, or should if they're being followed. Here's the definition of negligence you'll have in the verdict form. I'm sorry, in the jury instructions. The judge already gave this to you, but I'm going to go over it with you for just a moment. It makes sense in the way we order our lives safely toward each other. Negligence is the failure to use ordinary or reasonable care. It is either doing something that a reasonably careful person would not do, or a failure to do something that a reasonably careful person would do, under all the circumstances in this case. It's clear that the hotel was negligent on a number of scores. And indeed, if you accept Mr. Barrett's testimony, which you know what I think about that, even then, what were they doing giving him access to a telephone that you could call up and find out somebody's room number upstairs from downstairs? Sorry, don't buy it. But if you do, that's on them too. That's called negligence. Now, on the negligence, burden of proof. So let me just talk about this for one moment so that this is one of your tools as a juror, as a jury, in making your decisions. Imagine I'm the scales of justice. I'm Mr. Justice, not Lady Justice. And in a criminal case, you always hear about the burden of proof being beyond a reasonable doubt, right? And what that means is, because we are talking about somebody's life or their liberty, we make the government prove that case against that person beyond any reasonable doubt. In a civil case, that's the reason those cases take so long. You got to pile on so much evidence because you got to prove it beyond a reasonable doubt. In a civil case, the burden is different. And if you hold Erin Andrews to the criminal standard, you're shortchanging her. In a civil case, the burden of proof is what is more likely than not. 51%. What's probable as to what happened? Now, you know, all the documents and common sense tell you what happened. The only thing that they try to get going for them is the testimony of a convicted felon who has every motivation to want to hurt Erin Andrews in this case. I'll tell you what, though, we didn't need to prove it beyond a reasonable doubt, but I think we have. I think we've tipped the scales of justice so heavily in favor of Erin Andrews in this case, and it's not because of Randy Kennard or me. It's because of the evidence. The evidence is so strong, and the evidence is in the documents. The only documents that could possibly back up their story in favor of Mr. Barrett are documents that they've never shown you. Why? I think it's because they don't exist. I want to point out something about negligence. Nowhere in the instruction on negligence does it say that they had to be negligent on purpose. It is not an intent issue, it's a negligence issue. If somebody rear-ends somebody else at a stop sign, they didn't intend to hurt them. But they may have been negligent in the way they drove, which is why they hit them and hurt them. And the law requires the driver to be held accountable for the negligence, even though the driver didn't intend to do it. Now, we know what Mr. Barrett's intentions were, but the case against the Marriott has to do with their overwhelming negligence in putting Barrett in position to be able to do what he did at the Nashville Marriott. Cause. The court read you a long instruction on the word cause, that the negligence must cause the harm. It must cause it in fact, and it must cause it also legally, and really that's sort of illegally, but the term is used legally. It must be causing it because it was something that was foreseeable. Okay? So, I think we've proven overwhelmingly here that they knew the dangers associated with telling someone that Erin Andrews or any one of us is at the hotel. And then second, for putting somebody unknown to Erin Andrews or any one of us, somebody next to our room without telling us. Remember what Erin testified to? If she had been told that there was this strange man who wanted a room next to her, she would have called the police and gotten out of there. I'll tell you the first thing I think she would have probably done, lock and deadbolt that door. What's going on here? And call the police and have them escort her out of there. Any one of us, if we were called in our hotel room and told that, would go, what's up with this? And be able to take actions to protect ourselves. Not just go on about our day, take a shower, and in our most private moments, be naked in the room, combing our hair, thinking about the day as a 29-year-old young lady. So I mentioned foreseeability. You'll see the word foreseeability in the instructions. Let me talk about that with you for just a moment. Because foreseeability does not mean that the hotel had to foresee Barrett in particular doing exactly what he did in particular in the manner he did it in particular. They don't have to foresee that. You could never hold the hotel liable for horrible failures of standards if they had to foresee every little thing that was going to happen as a result of the violation. No, that's not how it works. Foreseeability means that they knew or should have known, that they could foresee that if they violated the standards, it could put somebody in a position of danger. Isn't that what this is all about? Isn't that what these standards are all about? To protect us all from people that might... I mean, when somebody asks for a room next to somebody else, you can't just assume that's a good-natured person. You've got to wonder, why? What's the story here? And if they call the hotel saying, is so-and-so going to be there, when they could call Erin Andrews herself if they knew her and asked her if she was going to be there, if they call the hotel and ask it, isn't the hotel supposed to think, wait a minute, why do you need that information from us? What's afoot here? But there is no question in this case that there was foreseeability, but I'm going to take you a step further because we didn't leave any stone unturned here in trying to do the job because Erin Andrews was willing to take that stand, and so we're right there with her. So, wait a minute. I'll take a deep breath for a second. So remember that form that says secure peephole that's supposed to be checked with periodic maintenance, PM, preventive maintenance, remember that? And Mr. Davenport admitted that that form existed since at least 2005. And so I asked him some questions about it in front of you here, and here's what he testified to. These quotations we have are taken from the transcript of this trial in the courtroom. Question. So this is far enough back. That was 2005. So we were referring to the fact that this form was used since at least 2005. It said secure people. So this is far enough back that you all could foresee that somebody might try to take a peephole that wasn't tight enough off the door and look inside. It was far enough back that you even had it on a checklist in 2005, correct? Yes. They could foresee that somebody, maybe they couldn't call him Barrett, maybe they wouldn't know what day he was going to do it on, maybe they wouldn't know that it would be Erin Andrews. They could foresee that people might try to take the peephole off if it wasn't tight. Now let me ask you a question. Why would somebody inside the room unscrew a loose peephole? Only people outside the room would unscrew a loose peephole, or a peephole that was only tight enough that you could unscrew it with your fingers even though it seemed it needs to be tight. But the real point of this testimony was they could foresee that you put somebody up there who knows somebody else's room, unbeknownst to the person in the room, and there's a risk that they're going to want to take off that peephole. He also said, question, and you all could foresee back then, that's still 2005, it's before this happened, you all could foresee back then that if it wasn't kept tight, somebody with bad intentions. Do we think Barrett had bad intentions? Somebody with bad intentions could come up and get that thing undone, correct? Yes. Now that was the guy who was one of the supervisors of preventive maintenance for the Nashville Hotel, for the Nashville Marriott. They could foresee exactly what happened here, and if they try to defend themselves saying, how could we foresee this, it flies in the face of the evidence. And by the way, it just wasn't Mr. Davenport that acknowledged this. Other people did too, including Mr. Delmarva, Even Mr. Barrett, withdraw, even Barrett said that the way he learned how to do this was he saw a maintenance or a hotel worker doing it at another hotel a year earlier. And I'll tell you what, I'm not relying on that testimony at all, because I think you can take his testimony and you can deposit it in the nearest shredder machine, because he is not to be believed. But you heard it from Mr. Delmarva, from Mr. Davenport. Mr. Davenport even acknowledged that that little peephole there is a place of danger if not properly secured and maintained. And so what else didn't they bring to court? Documents? Where are the preventive maintenance checklists? We know that it's room by room, who did the work, how it was done, when it was done, and all the check marks. Where are they? Was it being done? I don't know. They don't have the documents, they say. Okay, here's the next point under the law. Under the law, there can be more than one cause of an incident. So don't just lock your brain in there and say, well, Barrett did this, and so therefore it can't be anybody else that's involved. Not true. Quick example. Four-way stop, pedestrian on the opposite corner. Two cars come along and they both blow the stop sign, hit each other in the middle of the intersection, slide across the intersection, and damage the pedestrian. There were two causes of that incident. Got it? So you'll see something that says that nothing is a sole cause necessarily. It's for you to decide. So as you know, we think Barrett is there, but we also think that the Marriott's negligence put him in position, enabled him to do what he did. They might not have actually known he was going to do what he did, but the failure and the violations of the standards and principles allowed him to do it. And they knew that those violations produced danger, whatever that danger would be. So, another thing you'll hear about is superseding cause. And y'all, I'm almost through this law part of it, okay? So hang in with me a little bit longer. Superseding cause is an argument that they will make, that somehow Barrett, when he put this up on the internet the following February, whenever it was, that was a superseding cause to anything they did. And therefore they should have no responsibility at all. Well, that's just a bunch of hooey. Because you see, they are responsible for the dangers that they can foresee from their failures in their conduct. So once they set this up where by their negligence, not intending to, but by their negligence for Barrett to be able to do this, when they put him in position and enabled him to know where her room is, to put him next door, to do all the other stuff we talked about, to even know she was in the hotel, all of the failures and violations of standards here that even they admit to some of them. Once they did that, he puts it up on the internet, that's on them. Now let me give you an example of what a real superseding cause is. Rear-end accident. Somebody gets a whiplash, and they're in pain for a couple of weeks. And a couple of weeks later, they're walking along with one of those collars on that the doctor gave them, and a tree falls and hits them on the head and turns them into a quadriplegic. That would be a superseding cause of harm, not what happened here. What happened here with Barrett flowed directly from the consequences of the negligence of the Nashville Marriott on September 2nd and September 4th. And maybe even September 3rd, if that's the day that they put him into that room and put "do not move." It may have been September 4th when they put him into that room and put "do not move," because they were trying to keep their Marriott Silver Rewards member happy. You know, this was the part of my discussion with you where I was going to talk about the violations. But I am so wrapped up in this case that I think I've already talked about them all, haven't I? I can tell you they shouldn't have told him that she was staying at the hotel. They shouldn't have accepted putting him in the room next to Erin Andrew and putting him there unless they told her first and made sure it was okay and let her protect herself. They should have been properly maintaining the peepholes. Oh, here's one. Cumberland Security. Do y'all remember Mr. Mazaluskas, who testified as the second witness on videotape? He's the one that had recommended to the Nashville Marriott that they needed more security, that they needed it 24 hours a day, not just overnight, and that they needed more cameras, and that some of the cameras weren't even working? Now, you know what? I'm sorry. I believe that those things create a deterrence. Barrett testified that he didn't want to get caught. Well, if he didn't want to get caught and he feels like there's a security presence and cameras or whatever, he's less likely to do it. It's called deterrence. But you know what else that testimony told me about, and I think told you, was the attitude of the Marriott on this subject. The Nashville Marriott was unable to spend the little bit more money a day it would take to have 24-hour security, so that when we check in there with ourselves and our families, whether it's on the concierge floor or another floor, that we're all protected. It's attitude. That's what that testimony really tells you about. So many acts below the standard of care, and if the phone system was his access, that's another act below the standard of care. It's just that I don't buy it, and you shouldn't either. It doesn't fit the evidence, and it definitely doesn't match the documents. So, the first question, okay, wait, y'all. The first question, I got most of you back here. The first question on the verdict form is the one that the judge says, finding fault against Barrett, okay? The second question is, do you find the defendant, Windsor Capital Group, Inc., to be at fault? Absolutely. They bear fault for what happened here. They could have cut this off at the beginning. They could have cut it off halfway through. They could have cut it off just before it was going to happen. I mean, the chilling story of Barrett walking by her room after they gave him room 1049 per his request, and the documents that was already in the system when he walked up to Jackie Dement, according to her. He walks by and he hears her on the telephone. Who knows who it was with? She talked to her mom and dad every day. And then he comes back out a bit later and he hears the shower, right? That's after he's taken out that peephole that he said took him about a minute to take out, right? Remember how long it took Mr. Del Marva to unscrew a peephole with his fingers? 50 turns, right? About a minute. Took it out, hacksawed some of it off, put it back in so that it looked like it was still there. Later on he comes out, he hears her in the shower. Then he goes back into his room with its double beds, comes back out and videos her. Did you find Windsor Capital Group, Inc. to be at fault? Absolutely. They enabled all of that. And really important point, they don't have to know that's what he was going to do. They don't have to intended that harm be done to her. If they're negligent and their negligence was a cause of the harm, they bear fault. So Windsor, you remember, is the company that had the management contract on the whole place. The next question will be about agency. All right. Deep breath here. Remember when Mr. Kennard put Mr. Peskind on the witness stand a few days ago? I'll help you remember it. It's the one where you saw the duck. Okay? And I'm sure you all were sitting there going, why are we going through all these little details about the contract between Windsor and West End and blah, blah, and then what about this duck thing? So now I can tell you what that was all about. Windsor was hired to run the hotel by the owners, West End. You all know that. There was a written contract between them. You all know that. The contract said some things and other things, and he went through those with you. But the reason he did the duck is because they want you to believe that Windsor was totally independent from West End. And that's not what the evidence ended up showing. Windsor was working as an agent of the owner West End, doing the managing for West End. Here's the jury instruction on that. The relevant factors on whether it's an agent or an independent contractor are these. The agreement. Let me stop you. Remember, Mr. Kennard went through the agreement virtually line by line in some places, showing the kind of control that West End had over the hotel. They weren't just mailing a check into somebody over in somewhere and saying, you just do everything and we're not going to be involved. They were involved. The conduct of the parties. That's why Mr. Kennard was going through that with Mr. Peskind. The right of West End to terminate the contract at will. They had that right. They could terminate that contract at will. The sharing of the profits. Remember the whole story about how they make their money, Windsor, from the profits of the hotel? The right to control day-to-day activities. The right to control. Whether they controlled it or not is not the question. It's the right to control the day-to-day activities. That's something that West End definitely had. They were the owners, and they retained the right to control day-to-day activities. Joint decisions in the day-to-day business matters, that was covered. The right to make final decision on security matters, that was covered. Any other factors the jury may consider relevant. This was a very intertwined relationship with a lot of power that still resided in West End, and you all know it. You saw it in the evidence. You heard it from Mr. Peskind. And when Peskind said all that, he then tried to say, but the document, the agreement says that there'll be an independent contractor. Well, what the law says is, if you need to pick it up, it's okay. What the law says is that you don't just make this decision because somebody wants to call themselves the right to, and that's why he went through all that, and that's why just because they call it an eagle, if it talks like a duck, and if it walks like a duck, and if it quacks like a duck, it's not a fish, it's a duck. So, agency. Do you find that Windsor Capital Group, Inc. was the agent of West End Hotel Partners, LLC? Your answer to that absolutely should be yes. So far you've answered the first two questions yes. Even if you answer this no, even if you think that Windsor was independent contractor from West End and that West End was not the principal of Windsor, Windsor is still responsible. By the way, consider the fact that Windsor and West End have the same attorneys. They are totally tied together. Okay, the next thing I'm going to talk about, before I talk about the award that I think you should be making, that Randy Kennard thinks you should be making in this case. Let me talk about one more legal matter, and that's percentages. Question number 4. Defendant Michael David Barrett is at fault. If you find Windsor, Inc. to also be at fault, let me stop you there. If you also find agency for West End, then that answer is going to include, in the judgment by the court, West End. We don't repeat West End here because West End's responsibility is based on the responsibility of Windsor as its agent. Got it? So that's why you're just seeing Windsor up there in this next question. So whether you find agency or not, you can still find in question number 2 would have found that Windsor Capital Group, the managers that employed all these people at the hotel and set the policies or the lack thereof and decided whether it would be lenient or whatever it was, that they are responsible regardless of agency. Okay? So, when you get to this one, if you find Windsor Capital Group, Inc. to also be at fault, you must apportion a percentage of fault between defendant Michael David Barrett and defendant Windsor Capital Group, Inc. So what you'll see on the verdict form is a place to put in percentages. Now, you know, if you think about it, if they hadn't told him on September 2, oh yeah, Erin Andrews, she's staying with us, yeah. None of this would have happened. You could almost say this is all their fault. But I'm not going to suggest that to you, but you almost could. I could understand why, from Erin's perspective, she could believe this is all. Now, how dare you tell them I'm going to be there and not tell me that you told some strange person on the phone that I'm going to be there so I can protect myself, so I can have a choice, so I can consent or reject or take action or do something. How dare you? Or on September 4, when they complied with his request, without picking up the phone and telling her, how dare you? I could see why she could feel that it's 100% on the hotel. But I'm not going to suggest that to you. Because Barrett is Barrett. And he's a defendant in this case too. So I don't know what your percentage will be that you will find. I do know this. Barrett couldn't have done it without the negligence of the Nashville Marriott. The repeated violations, one after another, of the standards that are there to protect us all and our families, our children. So where you put that percentage, I don't know. But I'll tell you one thing I know they're hoping for. If you make it a low percentage on the hotel, You reduce the significance of your verdict in this case to the Nashville Marriott. You know, Erin Andrews is a victim who's been re-victimized by the way this case has been defended in this courtroom. Rather than stepping up to the plate and saying, you know, we did it wrong. We're sorry that our manager didn't call you and tell you about this guy. We accept responsibility. And now let's look at your damages. Instead, the Nashville Marriott has done it again. Right here in this courtroom, not accepting responsibility for their own actions. And these days, too many people do not accept responsibility for their own actions. That's why we have juries and courtrooms and the greatest system in the world, as the court just told you. And that's why you will always be Erin Andrews' jury. Percentages. I don't know where you're going to put it, but make sure it's meaningful against them. Because remember something that the judge said? When you make your award of an amount of money, don't reduce it for percentages, because the court will then reduce it for the percentage. So if you reduce it for a percentage in your mind, then the court's going to reduce it again. So when you make your award of damages, make it for the full amount of harm that you believe has been done to her, and you make that percentage against the Marriott meaningful. Because your verdict will be putting a value on following the standards. So, the last topic. Damages. How much you should award for what happened to her. That's going to be the fifth question on the verdict form. And it will apply to both Barrett and the Nashville Marriott. And then the court will apply the percentages. Okay? So let's think about this for a second. You have to stop and think about who Erin Andrews is. You all have met her, although you have yet to shake hands with her, give her a hug, or anything like that. You haven't talked with her. She'll be here the whole time waiting for your verdict, and she'll be here for your verdict because she is standing up. But Erin Andrews was a 29-year-old young lady who did not believe in celebrity for celebrity's sake. You know how we have some of these celebs these days that just seem to be celebs for celebrity's sake? They don't seem to have any talent or ability or whatever. They're just celebs. Well, she happens to have attained that status, not because that's what she was looking for, but because she's very talented and she has worked her tail off from the time she was very young and saw Hannah Storm and had that dream. But she was also a tall, thin, kind of gangly young lady as a little girl. I remember some of those when I was a kid, and I never got a date with them for obvious reasons. But she was tall and thin, and she was shy about her body. In the dance competitions or whatever, she would change in a different room because she was not proud of her body. Now she has grown into her body and she's a beautiful woman. But the early things in our life lay down pathways, tracks in our brain about things like modesty. And these days, some people go out there and just let it all hang out. I don't get that because, you know, I grew up in El Paso, Texas, and people didn't just let it all hang out. That's the pathway set down with me. Well, she had a pathway set down in her neural pathways in her brain and all that stuff of modesty in terms of being naked. That doesn't mean she doesn't want to look attractive. It doesn't mean she doesn't want to dress in a glamorous way. You saw some of the photos. Why did they put those photos up in front of you? The expert witness admitted to Mr. Kennard, Dr. Brown did, that she didn't need those photos for the basis for her opinion, and yet they threw those photos up in front of you from Dancing with the Stars and all that stuff to try to make you think that this being naked in her private time on the internet is not killing her every day. Don't let them get away with that any more than letting Barrett's story be the basis of your verdict and helping him hurt her again. So you just take those pictures and you forget about that because that has nothing to do with this. Some people can dress beautifully but do not want to be photographed naked without their consent or knowledge. So anyway, celebrities. The public persona can be so different than what's going on in that person's life on the personal side, right? I mean, you saw in here this poignant testimony of her. I mean, the red that was, even Dr. Brown said that she saw the red coming up. The red that when she was on Oprah, you'll have these photos in there, was coming up on her neck, the rash that was coming up as she was talking about this thing. Never happened to her before this happened. Or here in the courtroom on ET when they had the camera that's been in here watching everything that's going on, and you could see the red starting to come up the side of her neck. Or when she was on the witness stand testifying, and Dr. Brown could see it because she was probably watching on TV what was going on as it's getting streamed all over the country. So what they did was, it happened to the worst person it could happen to. Because she is well known. She's beloved. And that would take that many more people to the internet. So the more her career grows, as she tries to cope with this the best she can, the more her career grows and develops, the worse this other side of it becomes. And I thought to myself, you know, she's really worked to develop a great career, and I'm so proud of her for not giving up. You all saw the video. If you knew, never mind the you. Her knowing that that's on the internet for the rest of time, and she still pulled herself together to get back to work. Well, we know it's a coping mechanism, but what does that say about her resolve and her commitment and her goodness? And they seem to want to penalize her, in this case on her damages, saying, well, she's still doing well in her work, so everything must be not as bad, it must be really mild. Mild malarkey. This is a post-traumatic stress disorder problem for which there is no post. It's every day. She knows people are looking at her naked on the internet every day. She gets tweets and social media and emails and catcalls at the stadium all the time. She gets the social media every day. Can you imagine what it's been like during this trial? And she's had the courage to do this because of what's involved. But sometimes we don't know the personal side of somebody. I'll never forget the feeling I had when one of the greatest performers that I've ever seen in my life, who I thought was a happy, put together, wonderful guy named Robin Williams, hung himself. We have to recognize that the people we see on TV, like Erin, also have a personal life. And sometimes that personal life is much more challenging than when they light up in front of the camera. In fact, did you all notice, remember how I was going, let's lighten it up a bit, when I was asking her questions, and then we get into something heavy again? Did you see how she suddenly beamed and lit up when we started talking about football again? Or about sports, or about the coaches she knows? And it was like a different person. And then we go back into that personal side of this being naked on the internet like this for the rest of her life. And I'm sorry, it's hard to call it just post-traumatic stress disorder, because the trauma happens day after day, and it's never going to stop. This is not a one-time event that you go and get therapy and help for and then learn how to deal with it. This is not going to stop. And long after your verdict, this will still be going on, and your verdict has to account for all of that, past and future. All she wanted to do was to be a respected professional. So what amount of damages, if any, do you find were sustained by Plaintiff Erin Andrews? Question mark, and then there'll be a blank for you to fill in the number. So I'm going to give you another little piece of law. Hang in there. And then I'm going to tell you something about what I think you should award. Erin has shown you that she experiences severe emotional distress. I mean, it's pretty severe when you have a rash start to develop up your body whenever you get into the subject matter. I've had some tough moments, but I've never had that happen. Or trembling, or heart pounding, or vomiting when the FBI said, you've got to look at this with us to help us try to identify where this happened. And thank heavens that one little angel applique was on the back of her jeans so they could figure out when and where it happened, because she only wore those jeans once, and that's how it came back to the Marriott. And that's how, when they got the documents out, just like you've seen, they were able to figure out how and when this happened. Because if that applique had not been there, this very, very important trial would never have happened. So the things you consider are evidence of physiological manifestations, physical stuff. That's what I was just talking about. The throwing up, the rash, the heart pounding, the trembling, all of those things that show a physical reaction to what had happened, the vomiting and so forth. Number two, evidence of psychological manifestations. And there's a whole list of things under there. Remember when I had her on the witness stand and I asked, do you experience humiliation? Do you experience embarrassment? And she just broke down and said, I'm so embarrassed. Imagine how she felt that Thursday afternoon when y'all were looking at the videos. I can't just imagine how y'all felt. All the psychological manifestations, there's a lot of words there, and she fits virtually every one. Evidence of treatment. You know, she treated in New York with Lauren Comstock, and she treated in Los Angeles with Dr. DePay. Both of those things helped. But the idea that with a repetitive trauma like this, every single day that she wakes up in the morning and she knows that there's a certain number of people, by the statistics that Dr. Jansen from Penn State University, who's an expert in the field, told you about, there are people looking at her naked on the internet every single day, which is why she gets catcalled in the stadium. And they are different kinds of catcalls than what she used to get. It is one thing to be an attractive woman and to be out there doing your job, and some drunk people up there are calling out saying, hey baby, you look pretty hot, and you know, I really like you, and I'd like to get together with you, and we could have some fun together, and you know, what a figure, and blah, blah, blah. There's a difference between that and, hey baby, I saw you naked on the internet, and other stuff about what they saw that is so ugly and so graphic that we decided not to tell you some of the stuff she hears and reads about herself and her body. Because you see, if somebody's just catcalling, you can just flick it off. But if somebody's talking about seeing you naked on the internet and you know it's true, the vulnerability, because you can't just flick it off. You can act like you're flicking it off, but you know that it's true. Evidence of duration and intensity. Well, we know it's been going on for 7 years, and we know it's going to go on for another 45. And there will be those moments, like sitting down with her kids, as she said, and trying to tell her kids, find the right time when they're old enough to tell them, but still young enough that they would not have been told it by other kids at school. Think about that choice. When is my child going to be just old enough that I can say, let me tell you, something happened with mommy years ago, and it's not mommy's fault, and you shouldn't feel bad if kids bring it up at school. Or maybe not have that conversation, and one day the child comes home and says, Mommy. And then grandchildren, I mean, you heard the evidence. Duration and intensity. Other evidence of significant impairment in daily functioning. Think of the way she is when she goes into a hotel room. And who can blame her? Any one of us would go through the same ritual if we were experiencing what she's experiencing on a day-to-day basis. And what about the impact on her personal life? What about her fears and concerns for more of this going up on the internet from Barrett or who knows who else? What about her conversations with her boyfriend? Her irritability, her explosiveness when she's in family relationships, even with her parents who she loves so much. She is in a state of humiliation, and she is completely alone on this. Think about it. No matter how much support we all try to give her, in the end, at the end of the day, she's stuck with this all alone. It significantly impairs her personal life, even though her professional life, you know, it struck me on Monday evening after she was done with her first day of testimony. it struck me that in one way, she's living her dream, isn't she? She's sought after. She's doing what she wants to do and worked so hard for and that she has the talent for. She's recognized for her achievements and her accomplishments. On the one hand, she's living a dream, her dream. On the other hand, she's living a nightmare. It's both. And they're side by side for the rest of her life. Remember the diagnoses by the various doctors? Depression, adjustment disorder, and post-traumatic stress disorder. They're all on the same spectrum, apparently, at least adjustment disorder and post-traumatic stress disorder. And she's been diagnosed with these things. So the last thing I'm going to put up here is a timeline. And let's just take a quick look at what goes. And the reason I'm going to do this is counsel mentioned during jury selection that this case was for $75 million. You remember that? $75 million is a lot of money. It's a lot to you, to me, to everybody in this courtroom, to everybody in Nashville. And I want you to know right up front that I recognize that. And it will be left to your sound discretion as 12 jurors, the voice of the community, to come up with a proper number to compensate her and to express to all of us, to her, to her parents, to everybody here, to everybody out there, and to the defendant, Nashville Marriott. It will be your verdict that tells us the value of the safety we've been talking about and the protection we've been talking about. But let's take a look at the little timeline here. July 2009, right? And today we are in March 2016. 7 years have passed. And what did we hear from Dr. Jansen about those 7 years? How many people have looked at this? 16.8 million. Now let me remind you of something. That was a very conservative number. That was a number that assumed that each time that somebody was viewing, it was just one person. Well, now how often do you think that that's been the case? How often do you think that just one person was watching? If it's an average of 2 people watching each time, then you double that number. But let's take it very conservatively, because we told Dr. Jansen we want this to be conservative. 16.8 million. He said that before the trial began, which would necessarily ratchet up the numbers, I think. Before the trial began, for the 5 or 6 months before that, what was it, about 300,000 people looked at it conservatively? A year. So then we look at the future. 45 more years of repeated trauma from this to her, having to deal with it every day, adjusting her life because of the impairments to her daily activities over this. If you take those numbers and you play them out for 45 years, Well, let's back up. If you take the 16.8 million that conservatively watched already, and you say for each one of those it's $1, you're at 16.8 million. If you then go into the future at 600,000 a year, even if you begin to taper it off in her later years, well, you figure it out. So, I don't know what the right number is, ladies and gentlemen, but I do know if you look at the rate at which she gets looked at this way, which certainly explains all the social media, the catcalls at the stadium, all of this stuff, and you just multiply each one by $1, let alone $5, but you multiply each one by just $1 and add up the past and the future, you tell us the right number. What I do know is it should be quite significant. And her hard work and success should not diminish what you award to her for what's happened to that part of her life that's been affected by all this. I will say this much. As she moves into the future, something she will never forget is coming back to Nashville, standing up for these principles in a court of law, and she will never forget your verdict. Thank you.
Okay, ladies and jury, we'll take a 10-minute recess.
All right.